ANC NEC member Dakota Legoete says the NPA's case against Ace Magashule is weak. He maintains that Magashule is being charged for the shortcomings of his juniors and not because he is corrupt. Now, for more on this, let's speak to Nthabiseng Dubazana, who is an attorney. Nthabiseng, thank you so much for your time. Now, he goes on to say quite a bit in his writing, Dakota Legoete, that is, and one of the things that he says is that the NPA's case is weak. What are your thoughts on that?
Thank you for having me. Firstly, I'm not sure where he would get the idea that the NPA's case is weak simply by looking at the charge sheet. The charge sheet does not have the details of statements of witnesses. It is only an outline of the allegations or the charges against the Ace Magashule. So what happens in a criminal setting, a criminal court, is that you as the attorney or the accused of the attorney of the accused or the accused, you will receive the charge sheet which outlines the charges that your client will be facing. So it will be saying something along the lines of, on or about the 21st of July 2021, the accused did unlawfully and wrongfully do 1, 2, 3, 4, and then that's where it ends. It doesn't detail as to how it was done, when it was done, times of the sort. It's just the charge that he'll be facing. So obviously, when you look at the charge sheet, that's all you're going to see. So right now, the attorney of Ace Magashule does not have the docket with him. So as a result, he does not know what exactly his client is facing. So once the attorney now has the docket content with him, once all the investigations are complete, my understanding is that there's about 3 more people going to be added as a co-accused. So once everything is done and dusted and the matter now goes to the High Court, we can now proceed to trial. Then the attorney is going to apply for copies of the docket and then go through it with his client. And therefore, he will assess, once he has all the statements, whether or not there is a case against his client. Right now, there really isn't any platform that anyone can say there is no case or there is a case against the Ace.
Now, one of the things that he also mentions, and you've spoken a little bit about it in terms of the charge sheet, is that he says the charge sheet paints a dangerous picture which may well taint the integrity of our state institutions. Now, will that hold up in court? Because, I mean, I don't even know who's painting a dangerous picture here when you're questioning those charges that he's speaking of.
No. It will not hold in court. Like I said, he has no leg right now to stand on. I think it's just a matter of venting. It's a matter of being upset, or perhaps his friend or colleague is now facing charges that he feels he should not be facing. But right now, he really doesn't have a leg to stand on. The court will then, mind you, the court will only know once the trial starts whether or not there's merits. The presiding officer, who should be the judge, will not know the contents of the docket. Only the state's prosecutor and the attorney, the defense attorney, will know what's in the docket prior to the trial actually starting. The judge will be hearing the matter as the trial proceeds and witnesses are being called one by one to the dock to give evidence, and they're doing examination in chief and cross-examination and stuff like that. But only at the end of the trial will the judge now have an idea whether or not Ace will be guilty or not guilty. But prior to that, the work now falls on the defense attorney, whereby after going through all of that, can of the 15 charges I think there are, he can decipher that after speaking to my client and assessing the merits of the docket, I believe that of the 15, maybe 5 we can go to trial with. These other 10, I will do with representations because there's not merit or enough evidence for him to be convicted. And then they will negotiate with the state and then come to an agreement that, okay, maybe these 10 will not deal with them pertaining to your client. We'll deal with these ones, which are the ones that will go to trial. So it's going to be a long road before we get to a point whereby we know where we stand in terms of all the allegations ventured against the Ace.
Now, notwithstanding that Mr. Legoete has criticized the media, but I want us to unpack 2 of his statements that are directly criticizing the legal fraternity, as it were. He says, I'm of the view that the law must take its course, but equally that the constitutionally entrenched rights of the accused, such as innocent until proven guilty, and the legal principle of ensuring ethical, procedural, and substantive fairness are adhered to at all times. Where do you think that there was any unfairness leveled against Mr. Ace Magashule? In fact, even ethical and procedural fairness leveled at Ace Magashule. In fact, I think a lot of people would say that the legal fraternity or institutions like the NPA have been very fair.
To be quite honest, this case has not started. There's no procedural unfairness. Nothing has begun on this case. There's nothing you can say has been done unethically. There's nothing you can say procedurally was not followed. Nothing has started in this case. The only thing that has happened is that he had his bail application, he paid bail, and the matter is postponed for further investigations. Nothing else has happened. So I'm not sure what he's saying when he says that procedurally things were not done right. What is he basing it on? I saw also in the letter that he wrote that he was talking about cases stemming from 2015 that the DA had dealt with the Attorney General, etc., etc. Those were not criminal cases. They were cases that were dealing with other aspects. Whether or not those things were deemed or dealt with as criminal issues has no bearing on this case today. From 2015 to today, investigations have been happening. And then the DPP now has the docket in front of them and say, based on the investigation that have been done so far, there is more than enough merit for us to level these charges against the accused. So that is what is currently happening. Procedurally, I don't know what he's going to say was done unethically. When it comes to what was the previous one? I'm sorry, I forgot the first one. It was the legal fraternity's unethical procedure and?
He said that the legal principle of ensuring ethical, procedural, and substantive fairness are adhered to at all times.
Okay, so that one the constitutional part whereby you are deemed innocent before you're found guilty.
Until proven guilty.
That in itself, I think he's leveling it against the media more than the legal fraternity, because nowhere has he been deemed to have been guilty before he was ever found innocent. Do you get what I'm saying? So I don't know what he's saying when he says his constitutional right, in terms of the legal field at least, was trampled on, in that he's already deemed guilty well before his case can be heard. What can be done, I suppose, is that they can take probably the media houses who have in some way inferred that Ace Magashule is guilty of the offense because of 1, 2, 3, 4. They can take that up in a civil route. But pertaining to the actual court procedure and him being charged, it's only just started. It would be premature to take this matter on and say that the procedure has not been done, because then when you take it to a higher court, the SCA, for example, to have it on review and say that procedure was not followed, or appeal, then the court's going to look at you, but what are you basing this on? Because nothing has happened.
In fact, just to support your statement there, when he went further to explain what he meant, he said that the media and our law enforcement agencies, among others, seem to be guilty of pretended justice. Now, according to him, pretended justice is when you are guilty until proven innocent narrative that we are seeing. But going back to the charges, do you think that the NPA has more in its arsenal? Has it showed us all its cards, in your opinion?
Well, I think they've openly said that the investigations are not complete, and there's 3 more accused persons are going to be arrested for this charge. So at this stage, the NPA is more than entitled to hold the cards to their chest. They're not entitled to express or give out what they have, so that they can protect their witnesses and make sure that the investigations are not tainted or whatever. So yes, there is a lot coming that we're not aware of, that is yet to be shown to us. So it's just for us to wait and see. Once the matter goes to court and trial starts, that's when all these things will not be revealed. Remember, even when the attorney now receives the copies of the docket, he too is not in a position whereby he would want to expose what the docket says. Just now he ruins his defense on behalf of his client. So it's going to be very interesting to see how it's going to unfold.
Now, another thing that he pointed out, and that probably tells us a lot about how we should be reading at charges leveled at someone. For instance, he says, firstly, the preamble to the charge sheet, which is 15 pages long, reads more like a copy and paste of one of the Auditor General's reports of most government departments and state-owned enterprises over the past 2 decades, rather than a clear case of corruption. But surely this is part and parcel of the NPA's case to build a case around a suspect.
100%. Whether or not it is copy and paste, it's because they are every department in government, there has a portion whereby if you go against certain regulations, it is a criminal offense. So obviously, if these some certain crimes are not covered within the Criminal Procedure Act, so the different kinds of legislation have criminal aspects if you go against certain things within it. So if it is a copy and paste of what is done by the Attorney General, it's because the crime is leveled based on what is happening in that sphere of government. So it will come across saying that you have violated this and that and that and that, the way it would be set out by the Attorney General when it is just dealt with in the sphere of government before it goes to a criminal court. So whether or not it's a copy and paste is irrelevant. It is neither here nor there. The fact is that now at this stage, the state has to prove, I think that's the part he seems to have forgotten. The state has to prove beyond a reasonable doubt that the accused is guilty of the offense that is now leveled against him. So whether or not the charge sheet reads this, it has no bearing on the merits of the case. So I think it was a little bit premature for him to send out this letter. He should have waited a bit and seen if he would be privy to the docket content and see what is in there, then make the statement. But if he's not privy, then wait like the rest of us until trial starts and see if on whether or not there is merit to what Ace Magashule is being charged with.
And is there merit to some of the comments that he's making against the NPA and the Hawks by saying that state institutions like the NPA, for instance, may see their reputations tainted like that of the Scorpions? Very quickly.
I think he must just choose his words wisely. Just now he finds himself in hot water by saying that he should have leveled evidence against for what he's saying that they will be tainted. I think it was a little bit dangerous for him to step on that territory.
All right, Nthabiseng, thank you so much for your time. We do appreciate it here on the show. That was attorney Nthabiseng Dubazana.